Hi everyone and welcome to another ATC video. My name is James and I have a very special guest with me today, Liz Aitken. Liz, welcome. Just to start off with, can you please tell our audience a bit about yourself?
Sure. So I'm a workplace relations lawyer. My focus is really on advising businesses on all sorts of workforce-related management matters. So it might be setting up their workforces, the construction of terms and conditions of engagement of employees, contractors, labour hire workers with providers.
Great. So as an expert on the labour hire laws, can you provide a very brief update on the contingent labour hire legislation in Australia at the moment?
Yeah, that's very timely because there have been some critical updates recently. So you would be aware that there's a lot of attention recently around the exploitation of workers, and one of the responses to that has been at a state-based level through the Labor governments. They've introduced in certain states a new labour hire licensing scheme, and the scheme requires labour hire providers to have appropriate licences if they're going to provide on-hire workers. And similarly, it's going to be an offence if organisations are using on-hire labour from a provider that doesn't have that appropriate licence.
So what do you think HR, workforce and procurement managers can do to avoid falling foul of these new labour laws?
So it's going to be really important going forward, if you fall in one of these covered states, including Victoria, that you're only utilising labour hire workers that are from a licensed provider. Now, that's going to be also important for labour hire providers, that if they want to provide on-hire workers to organisations, that they do obtain that appropriate licence first.
Liz, Workpack versus Skene. We've heard a lot in the media about it lately. What's it all about?
This is a really great case to talk about. The judgement actually just came out last month. It's a full bench of the federal court decision. Workpack and Skene will drop the citation in the notes below. So the case related to a casual employee who had been working for a few years with a labour hire provider, and he was ostensibly engaged as a casual. He was paid a flat rate, $50 an hour. He had very predictable hours of work, regular, systematic, and this ongoing expectation of employment. Now, he was dismissed by his employer, and he subsequently made a claim for underpayment of annual leave entitlements. And ostensibly, if you're a casual employee, you don't receive entitlements like annual leave. That's reserved for permanent workers. The court ultimately considered this question about whether it would be fair to allow this worker to double dip, and they held that he was not a casual employee and therefore was entitled to receive the annual leave in addition to the amounts already paid to him. So this has a really big impact for those organisations that are engaging with a casualised workforce.
So Liz, you're going to be speaking at our upcoming Contingent Workforce Workshop here in Melbourne, and your colleague Laura Soden is going to be speaking in Sydney. What can we be expecting to hear from you at those workshops?
I'm really excited about joining you for this workshop because I think it's a great time to have this discussion. One of the key things I want to focus on is giving the attendees a 101 on what's been happening in the world of contingent work for the past year. Those critical legal developments that we'll focus on. We'll also talk about how organisations can be responsive to the changing environment and really take steps to minimise their legal risk associated with contracting contingent labour.
Fantastic. Well, Liz, thank you so much for joining us today. Be sure to log onto the ATC website and find out more about the Contingent Workforce Workshops. You're able to purchase tickets and there's a special 20% off discount code available at the moment, so do look out for that. Thanks very much for watching. We look forward to seeing you in our next video.